Good morning, everybody. Welcome to Staffordshire, to an actual live meeting, which is a novelty, but we are sort of keeping to COVID rules around the chamber. Because it is so hot, if anyone wants to remove the jacket, and I will be doing, please feel free to do so. It is going to be a nice weekend, and I think it's starting today. We are quorate, yes, so that's fine. Okay, we'll start the meeting at this point, and I will ask, please, for declarations of interest. So, sorry, I've got, I'm looking at the minutes and not the agenda. Right, shall we start again? Members and officers, have we any apologies?
Good morning, Chairman. Yeah, we've received apologies from Councillor Waring.
And I see that Jack Abrams is not here.
No apologies have been received.
Yeah. Can we register that he did apologise yesterday, so perhaps he missed it.
Yes, the reason it wasn't done this time is obviously the appointments were only made yesterday at Planning Committee, so it wouldn't be appropriate without having the training. Okay.
Okay, thank you. And the minutes of the meeting, which I just started reading, for the 18th of June this year, are we happy with them? Moved and seconded. Okay, thank you, and we'll sign those. So, moving into the main business of the morning, can we work with agenda item 4, which is the Wildlife and Countryside Act 1981, application for public footpath from B5027 to the footpaths at the Bents, PF34, Lee Parish. And I presume Claire's going to take this one. Sorry.
Mr. Chairman, it's me. Yeah.
Sorry, apologies. Claire waved at me and put me off. We've got a virtual report from David Adkins. We did this yesterday at the planning meeting. It worked really well. So welcome, David, and carry on.
Thank you. Thank you, Mr. Chairman, and thank you, members of the panel. I'll move straight to the recommendation, and the recommendation in this application is the route should be added to the definitive map and statement for the district of East Staffordshire. Members will have noted that the evidence supplied for this application is limited. We have one piece of evidence from one source, which is a deposited railway plan of 1845, and no other evidence has been forwarded by the applicant. Now, if this was a claim based on the balance of probability, clearly that would ring alarm bells. However, this is an addition. It's the addition of a route, and as such, we use the lesser test to reasonably allege the existence of the route, that the route subsists along the route A to B marked in Appendix B. Now, to explain this a little bit further, I wonder if members would be kind enough to turn to Appendix B and have the plan before them. And then from Appendix C, the deposited railway plan of 1845. If the latter plan can be rotated 90 degrees, so it's on the same north-south line as the map in Appendix B, then I can easily explain why one piece of evidence is actually sufficient to reasonably allege the existence of the route. If members have got those plans before them, they'll see at the top on the deposited railway plan of 1845, plot number 22. Plot number 22, in its southeast corner, has a dogleg or right angle. At this point, the path, the alleged route, joins public footpath 34 Lee. If that route, that dotted line, which is a tracing, which has been supplied by the applicant, is then followed down south in a southerly direction along all the field edges. Eventually, members will see that it emerges in plot 21A at the bottom, which is the area which the B5027 currently passes through. So that's the extent of the route. Now, we've got only one piece of evidence, but the probity of this evidence is very good. Because if we look at the notes that were appended to that 1845 plan, we'll see what we have is actually the book of reference. The book of reference lists each plot that the route passes through, and it also lists the liability for that plot. Each plot's numbered, and as we go down the list, we can see the landowners, such as the Baggots and the Levitts, feature quite heavily. There are 4 or 5 other landowners lower down that list, but in each case, we have reference to the Surveyor of Highways. Now, the Surveyor of Highways would only have had an interest in this route if there had been a public footpath passing through the plots concerned. There's no other reason that a Surveyor of Highways would have been involved and noted or mentioned in that book of reference if there had been no sort of public way or public path through those plots. This is significant, and it's certainly significant enough when we're considering the test of reasonable allegation. The path can be seen to go through all of the various plots as indicated down here, and for clarity, the word occupation road is given from plot 6. Now, this gives further credibility to the actual application because people could allege that, well, these routes were simple occupation roads and roads designed or routes designed for a limited number of people for their work purposes. But because we've got from plot 6 onwards reference to an occupation road as well as a footpath, then clearly we can distinguish that both these routes were of a different status. Because why else would the routes be mentioned twice? So I think that's quite important within that book of reference, that we can distinguish between an occupation road and the actual footpath. And the footpath is consistent in all of those plots. Okay. We had, because this is based on one piece of information, further exposition of this is really superfluous. It's self-explanatory. We did have 1 or 2 objections from the landowners concerned, and those have been addended to the report. You'll see on there that there is reference to wildlife in the area. We have lapwings, other birds, bird life, and lady smocks, flowers. One landowner, Mrs. Jane Brooks, is concerned that Natural England might not be happy with the route's existence if the order was made. However, all the points raised in that addendum are not material points that we can consider at Crow Panel, because we're only concerned with whether the route exists legally or not. So although these points are valid in their own right, for the purposes that we're actually considering this route, then they have to be discounted. Nonetheless, we're thankful for those comments, and we do appreciate the landowners sending them in. One point that Mrs. Jane Brooks did raise was in 1933, when the land was bought, the sales particulars did not show the route on the papers that they received. Now, 1933 is a considerable amount of time from 1845. This is an historical claim. So it's highly likely, or at least probable, that the route that existed in 1845 had ceased to exist in the records by 1933. And that's really all we can say about that point. That point was the most pertinent to the claim, although again, really has no great relevance to the application. So the recommendation would be, based on reasonable allegation, to add the route and to a width of 1.5 metres along its entire length from the B5027 to public footpath 34 Lee. Thank you, Mr. Chairman. That was a very brief report, and I'm happy to take any questions.
Thank you, David. Before we go to questions, could I ask 2 questions? First of all, has there been any representation from the local member?
No, Chair.
And secondly, just to inform the committee, I did have a phone call off Mrs. Brooks, who said exactly the same things as she said in the letter. and that's all been covered within the report. Okay, and that would obviously be a non-prejudicial interest on my part, so perhaps you should mention that. Can I throw it open to members for any comments? Paul?
Just to say to David, it may have been a short report, but it was full of evidence, so thank you for that.
Thank you.
If no one else can make any comments, I'll propose that we go along with it, and that we add the path to the definitive map.
Sorry. So we've got proposed by Paul, seconded by David, and can we have a vote on it, please? Okay. Yeah. Right. So that's passed. Okay. Can we now move on to agenda item number 5, please, which is Wildlife and Countryside Act 1981, application to upgrade public footpath 14 Cheadle to a restricted byway. And I think this was referred on from the last meeting, and Claire's going to give us an update on the questions that were asked.
Lovely, thank you, Chair. Yes, so this was heard at the previous panel back in June. The reason for it being deferred to today was because additional piece of evidence was received the day before the panel, quite late on. Unfortunately, we weren't able to access that document in that short period of time before panel. We have now had a chance to open the document. I believe you've got a copy of that additional tithe map. So they've provided, the applicant has provided a Cheadle tithe map dated 1842. The map shows the alleged route coloured in sienna, and all of the adjoining routes depicted in the same manner are also called coloured sienna. The applicant states that these routes are now ordinary vehicular roads. There is no numbering on the alleged route though, so there is no description on the route of the tithe award. The courts have said that this tithe documentation may be supportive of the existence of a public right-of-way, but the weight that can be given to these documents is a matter for a tribunal of fact at this panel. Such evidence on its own is not conclusive proof, and the routes may be shown in the same colouring, which is often in the colour sienna, as present public highways, which may indicate a similar status, that it is public but not the nature of those rights. In conclusion, therefore, then, it's your office's opinion that this further evidence does not alter the conclusions of the report. So therefore, if I can just remind you of the recommendation, that it's your opinion of it is the opinion of the officers of the County Council that you should not make a modification in order to upgrade this route to a restricted byway.
Nice and simple. Any questions or proposals on that? Paul?
No, excuse me. For anybody who's listening, we had a full debate on it last time. And this was just to discuss the additional document, and I believe we should go with officer recommendation.
Okay. Okay, so proposed, seconded, and I agree as well. So we'll just move at that point on to agenda item 6. Again, Wildlife and Countryside Act 1981. Application for an alleged public footpath between Hollow Lane and public footpath number IR/2248 Cheddleton Parish. Who's going to take this one? Claire, please.
Thank you, Chair. So yes, this is an application for an alleged footpath between Hollow Lane and public footpath IR/2248 in Cheddleton Parish. This application has been submitted by the Parish Council themselves at Cheddleton. Slightly different to the applications we've already heard this morning, this actually is based on user evidence. So in order for an application of this type to be successful, it will need to be shown that the public have used the alleged route as of right and without interruption for a period of at least 20 years prior to the status of the route being brought into question, or that it can be inferred by the landowner's conduct that he had actually dedicated the route as a public right-of-way and that right-of-way had been accepted by the public. In order for the right of the public to have been brought into question, the right must have been challenged by some means which is sufficient to bring home to the public that their right to use the way is being challenged. In this instance, it does not appear that there's been any challenge to the actual usage of the route by any person, nor have there been any physical impediments. Where there is no identifiable event which has brought into question the use of the way, Section 31 provides that the date of the application can be used as the date which the public use was brought into question. In the absence of any other major or identifiable challenge to this use by the public, the application date, which in this instance is the 14th of November 1995, will be used as that challenge date. Accordingly, the requisite 20-year period of use would be calculated retrospectively, the years 1975 to 1995, which is where the majority of the users provide their evidence of use. The application in this instance is supported by statements from 10 members of the public who claim to have used the alleged footpath over varying periods of time, and you do have copies of those statements at Appendix C in the report. An examination of these forms will show that of the 10 users, 6 of those have used it for a 20-year uninterrupted use of the route, and they have recorded the use between 1975 and 1995. Of the remaining 4 users, Barbara Hine claims to have known the route for 50 years, which actually predates the 20-year period. She claims to have mainly used the route for the first 25 years, which would be during the years 1945 to 1970, which does fall outside of the 20-year period. Barbara Hine further details that there is has she ever known of any stiles, handgates or notices? And Barbara Hine responds with saying that out of the churchyard into Limer's Field. She does not specify what it is that is there, so it's unclear as to what the obstruction potentially may be. The usage of Rachel Murphin is also a little unclear. She claims to have known the alleged route for 36 years and states that she's used the alleged way for most of her life on and off. This evidence can therefore be considered to be a good reputation of the alleged route. The remaining 2 users have not provided a number of years. Out of the 10 users, there is no claim that any of them were an owner, a tenant, or tenanting the land where the alleged route crosses. Although a number of the users have made reference to a stile, this would not necessarily be considered to be an obstruction or a challenge to members using the route, as stiles generally are viewed objectively as generally providing an aid to the public to use the route. None of the users have indicated that the presence of a stile has interrupted their usage, therefore cannot be considered to be a challenge. There is nothing in the information sheets to indicate that any of the users sought or were given permission to use the route. In this application, there are 2 affected landowners, which the whole route covers. One landowner has not responded, and a Reverend Derek Tinsley, who is the vicar of Cheddleton at St Edward's Church, has responded. He states in his owner evidence form that he considers that the route is public and no steps have ever been taken to prevent the presumed dedication of the path as a public right-of-way. In relation to statutory consultees, the Peak and Northern Footpath Society have indicated that it doesn't have any evidence to support or refute the application. Staffordshire Moorlands branch of the Ramblers Association confirmed that the alleged path is used by local people going to the church. They are of the opinion that the alleged route should be added to the definitive map. And Staffordshire Moorlands District Council has indicated that subject to the authority being satisfied by the evidence found, the path should be added as a right-of-way. In relation to the evidence that's been submitted, the relevant legislation is Section 31 of the Highways Act 1980, which sets out the tests which must be satisfied under statute for this way to become a public right-of-way through usage by the public. 6 out of 10 users can be shown that they have used the alleged route as of right, without interruption, and for a period of 20 years, and that would be sufficient to make the status of the route being brought into question. None of the users have used force to use the route, and that usage has not been in secrecy. Although the route does pass through a churchyard, and more specifically a cemetery, there is nothing in the evidence to suggest that this route is solely used to access for these purposes. All of the users confirm that they use the route for pleasure, and none of the users specify they are using the route to access the church. And the Reverend Derek Tinsley also confirms in his letter of the 5th of February 1996 that members of the public use the route as a, and I will quote, a throughway on foot without any intention of visiting the church or the churchyard. And therefore the route can be regarded as being public and not solely for the purposes of accessing the church. Neither the legislation nor the applicable case law sets out a minimum level of users that is expected or required to support a claim that a route exists. The case law does suggest that the amount of usage should be such that it is enough to bring home to any reasonable landowner that the public are using the way and that it has been as of right. It could be argued that the evidence from 10 users is not significantly high number enough to show that the alleged route is widely used, but it certainly indicates that there is a reputation amongst local people of the route's existence. The remaining part of Section 31 test covers whether the landowner has taken any action to rebut the statutory presumption of dedication. Often this is evidenced by way of notices or obstructions to prevent people using the path. In this case, the landowner in his letter and owner evidence form confirms that he is aware of members of the public using the route and that he, and I quote, has no desire to block these access points, and no steps have been taken to prevent this presumed dedication as a public right-of-way. Although the route may not be used extensively, the landowner is aware of the use and has not taken any action to rebut this dedication. The fact that the landowner is aware that members of the public are using the route and he did not take any overt action to prevent dedication of the route does not automatically imply that he was given permission to use the route. In the evidence before the panel, one could say that the use was such that it was very obvious to the owner. It has already been stated by the Reverend Tinsley and confirmed that he's aware that the route is being used and no steps were taken. Therefore, it could be argued that the owner acquiesced and so therefore it was an inferred dedication. So, in summary, as previously mentioned, the relevant statutory provision is the Section 31 of the Highways Act 1980. This requires consideration as to whether the use of the way has been as of right, as I've previously said, without interruption and for a period of 20 years, and whether or not there's evidence of any landowner demonstrating a lack of intention to dedicate this as a public right-of-way. The user evidence does show that 6 of the 10 users have met that requisite 20-year period, and the Secretary of State, when determining appeals in relation to Section 53 matters of this type, has accepted as few as 6 users where the evidence has been a high enough quality, accuracy and credibility. Although the quality of this user evidence is not high, it does show that the alleged route has been used by a reasonable number of people without interruption for 20 years. In addition, there's no evidence to indicate a clear intention not to dedicate the route by the owner. On the contrary, the owner's evidence is that he knew about the route and he was aware that members of the public were using it and no steps were taken to prevent that presumed dedication. In this instance, your officers consider that this use is sufficient to satisfy the test which is set out in Section 31 when considered on the balance of probabilities. It is evidence that has been over 20 years usage of the route, the evidence from the landowner is that he was aware of the route, and the evidence shows that the footpath is not being used as a route solely to access the church or the churchyard, as confirmed by the landowner and the user evidence. And with regard to the second part of the relevant section, whether the route is said to reasonably allege to subsist, the officers consider this test would also be satisfied. It is therefore your officers' recommendation that the County Council ought to make a modification in order to add the public footpath which is subject to this application to the definitive map and statement.
Thank you, Claire. Just 2 questions from me, or the first is a question, has the local member responded?
No, they
Okay,
haven't.
thank you. And the second one, I noticed, and you actually said in the report, the letter from the Vicar of Cheddleton was the 5th of February 1996. It starts to get a little bit historical when we're talking 21 years plus. Are you confident that the information other than that is up to date and
Yeah, we
relevant?
will be looking at the evidence as it was presented when the application was made. So we are looking for that 20-year period. It doesn't matter what's happened since that date. So we're happy with the evidence that's been submitted.
Thank you. Okay, members. We've got a move for the recommendation from David.
Okay. I'll gladly second it, but just give my reasons why I'm doing it. I mean, I've not heard a case presented that was as one-sided, really, as that over the many years I've sat here. If just going through it, really, there's been no challenges, nothing from a landowner, nothing from a church, going back to 96 even. It just shows the work that we've got to catch up on, really, doesn't it? And I thank our officers for doing it the way they're doing it. The user statements, everything is all there. And I'm pleased to second David's proposal.
Thank you, Chair.
We'll now move on to application number 7, which is the Wildlife and Countryside Act 1981, application for alleged public footpath from Stretton to the highway east of Bickford Grange Farm. This is quite a substantial report. Are you going to take this, Sam?
Yes, Chair. Okay. Thank you, Chair, members. This matter has been ongoing for some time and 3 reports have been drafted previously. The latest report being presented today will contain all material which has been put forward by the applicant and the landowner's legal advisors in all instances. I will proceed in a chronological order of events. This application was made by Mr. Martin Ray. In support of the application, he has submitted quarter session orders, 1910 Finance Act material, Ordnance Survey maps and 1950s Penkridge Parish Survey cards. The present landowner is Mr. Piers Monkton. Previous to this, the landowner was Mr. A.S. Monkton, who was the father of the current owner. Mr. A.S. Monkton completed an owner-occupier evidence form along with a cover letter dated the 17th of July 1997, detailing reasons why he believes the alleged footpath does not exist and objecting to the application. A copy can be found at Appendix F. Following this, Mr. Piers Monkton sent a fax to officers dated the 25th of July 1997, summarising principal reasons as to why the footpath does not exist. A copy can be found at Appendix G. Mr. Brewster of Bickford Grange Farm completed an evidence form dated the 6th of August 1997. A copy can be found at Appendix H. And on the 6th of August 1997, Mr. Piers Monkton completed an evidence form and sent a cover letter detailing reasons why he believes the alleged footpath does not exist and objecting to the footpath. A copy of this can be found at Appendix I. He also provided a copy of an estate plan dated 1833. This plan does not show the footpath. This can be found at Appendix J. Since this initial consultation, Mr. Piers Monkton has instructed legal advisors who submitted a letter of objection and supporting evidence. This can be seen at Appendix K. Finally, Mr. Giles of Ivy House Farm completed an evidence form dated the 20th of July 2018. This can be found at Appendix L. Moving on to the statutory consultees, Penkridge Parish Council has responded advising they have no comments to make. However, they do support any additional footpaths. Lapley, Stretton and Wheaton Aston Parish Council responded confirming they support the application, and the Ramblers Association responded advising they have no supporting evidence for the addition of the footpath. However, they do welcome all new footpaths. Moving back to the evidence submitted by the applicant, the 1827 quarter session order discontinues some highways in the same area and created new ones. The Plan enclosed shows the old and new footpaths. The alleged footpath is coloured brown on the plan and is marked by letters C and K. The order states, subject to a right of footway from the point marked C to the point marked K. This quarter session supports part A to B on the plan at Appendix B. The Finance Act material shows that tax relief was granted for footpaths that cross the plots referred to. An examination of the maps show that there are 3 footpaths in plot 610, and the routes are annotated on the accompanying map. The field book entries were originally compiled by entering the information provided by the landowner and would include any claims for easements and rights of way. For plot 610, the landowner did make a claim for footpaths. The valuers did note that there were public footpaths and made a note on the field book. They granted relief for the footpaths that cross the land, which they would not have done unless satisfied of their existence. The claimed route appears to be one of the footpaths shown on the plan, and the field book entries detail the footpath. It states there are public rights of way and therefore provides evidence that there were public highways with a recognised status of a public footpath. This material supports part B to C on the plan. Moving on to the parish survey cards, under the National Parks and Access to the Countryside Act 1949, all surveying authorities in England and Wales had to carry out a survey of their area and produce a map that showed all public footpaths, bridleways and RUPs, which were or could reasonably alleged to be public rights of way. The parish survey record cards varied in the quality and information provided. Some gave detailed descriptions of their routes, including any gates, stiles or other noteworthy features, while some merely gave a start and finish point. In Staffordshire, a substantial number of objections were received both from users claiming routes had been omitted or requiring upgrading from a footpath to a bridleway, or from landowners denying the existence of or disputing the status of a route. Penkridge Parish Survey cards support the claimed route from B to C. There was an objection received regarding the omission of the route. Copies of the parish survey cards can be found at Appendix M. I'm now going to move on to comments from the landowner, namely the objection letter and evidence submitted by Mr. Piers Monkton's legal advisors. Paragraph 12 to 14 of the objection letter sets out the impact the route will have on the affected land. Mr. Monkton has submitted annotated photographs and maps showing the impact of the proposed footpath on the land in its current form. However, issues such as security, privacy, safety or suitability of the land are not factors that we can take into account as a point of law. Paragraph 18 states it is assumed that the applicant is relying upon the common law test of dedication. This is incorrect. This application is under section 53(3)(c)(1) of the Wildlife and Countryside Act, which does not require dedication by the landowner. We would like to rely on the doctrine of lost modern grants. This means if a right has been enjoyed for at least 20 years, the court is willing to presume that a grant was created which evidenced such as an easement, but that the grant was subsequently lost. And so it can be presumed these routes previously existed. Therefore, dedication and acceptance would not need to be proved. Paragraphs 26 to 38 of the objection letter sets out detailed analysis of the Finance Act documents that have been submitted as part of the application. Plot 1268, which is raised in the objection letter, refers to Part A to B of the alleged routes. Officers consider that this analysis is correct. It does not support this part of the route. However, officers contend previously that Plot 610 does show Part B to C. Officers do not require the Finance Act material to support Part A to B of the route, As stated previously, the 1827 quarter session order supports this part. And so the objectors' comments on plot 1268 are irrelevant. At paragraph 43, they contend that the 1827 quarter session was subsequently appealed in the 1828 Epiphany quarter session. This is incorrect, that the order was confirmed in relation to the stopping up of various highways. This evidence was sent to the applicant to comment upon. He responded with 2 letters addressing the issues raised. Copies of the letters can be found at Appendix N. In the letter dated the 5th of December 2018, the applicant states the route depicted on the plan is incorrect. The commencement point of the path, as shown on the plan, has been positioned to the west of the junction, including Lapley Road and the avenue, which he states is incorrect. He further states the commencement point should be positioned to the east, in line with the junction of Lapley Road and the avenue, and not to the west of it. This is how it is depicted on the highway order plan and all subsequent maps that he has inspected, which were published between 1833 and 1900. The applicant goes on to state there is no evidence that the highways now, known as Lapley Road and the avenue, have been repositioned at any point. In the second letter from the applicant dated the 10th of December 2018, he sets out his response to the objections made by the objectors. He firstly states the quarter session order of 1827 does not consider anything other than public rights of way as stated by the objectors. They regard the order as being focused on the stopping up of rights of way and not whether they were public. The applicant further comments that the stopping up of specified highways in the 1827 highway order was subsequently appealed. In 1828, the appeal was heard, and in the 1827 order was upheld. The highways were to remain open with reserved rights for users on foot, as shown on the 1827 order plan. The text of the appeal decision by the court clarifies that the 1827 order and appeal were dealing with the public highways in Stretton. The applicant goes on to mention the remodelling of the estate, obstructions, and how the estate was freehold and not copyhold, which did not hinder any kind of dedication of the landowner. He continues to argue that the landowners are incorrect by stating the order extinguishes all and any public rights of way between points C, B and F. The 1827 order did extinguish user rights between points C, B and F, but not all, as the landowner states. He further notes that the express qualification of extinguishing some user rights within the order and recorded on the order plan by way of a brown tint was quoted, but subject to the right of footway from the point marked C to point marked K on the said plan. So the reserved right of way on foot between C and K was ardently confirmed by the order. The applicant lastly comments on the landowner's assertions regarding the Finance Act evidence. He asserts that it is notable that the owner of the arrendament 1268 acknowledged that a public path crossing the arrendament, as shown on the Finance Act's field book. The claim states public path as ordnance. There's only one route crossing the arrendament depicted on the Ordnance Survey map in a manner indicating it is public in nature, which could be attributed to this admission. The applicant asserts that the northern section of the application route crosses Finance Act Arrendament 610. The Finance Act records confirm that the landowner of Arrendament 610 claimed a reduction in duty value for roads on the public path over the land. It is stated that the public path claimed is now more likely to be that shown on the definitive to Whiston Hall than on the application route. I disagree. Firstly, there are 2 footpaths entered onto the definitive map that leads to Whiston Hall that are noted as footpaths on the base map used to create the 1910 Finance Act plan. can I just assert the fact that this is a quote from the applicant? Okay, thank you. These are now recorded as footpaths 0138 and 0140 on definitive map. However, the definitive map modification application route is the only one connecting with the 1827 and the 1828 old plan route and heading north to Bickford Weston. That is shown as footpath on the base Finance Act plan. It is therefore more likely than the application route comprises the path being claimed for within the Finance Act records. On the 5th of October 2019, the draft report was circulated to all relevant parties with all the available evidence appended. The Monkton's legal advisors commented on having previously provided a detailed analysis of the Finance Act documents. However, the report does not deal with these submissions only by simply stating that the officers considered this analysis to be correct. In response to this, officers state that plot 1268, which is raised in the objection letter by the Monkton's legal advisors, refers to part A to B of the alleged route. Officers now consider that this analysis is correct. It does not support this part of the route. It supports B to C in its place, as it shows this part. They further state that the 1827 order was not only concerned with stopping up, it included the reservation of a footpath as a limitation to the effect of the stopping up. They further state if the reservation was not explicitly confirmed in the 1828 order, that would indicate that the stopping up was confirmed without the reservation. There does not appear to be any other reason for the omission. Officers disagree with this comment. The 1827 order states, but subject to a right of footway from the point marked C to the point marked K on the said plan. If an action or event is subject to something, it needs something to happen before it can take effect. This something could be the stopping up of the stated highways. They also stated that even if the reservation of the footpath was confirmed, which they are not accepting, on the basis that the orders were primarily concerned with the stopping up, it is clear that any footpath so reserved would only be along the road to be stopped up. In response to this, officers state that the orders were concerned with the amendment and preservation of public highways. Preservation is the act of keeping something as it is. Therefore, officers claim footpath marked C to K was to remain as a public footpath. There is no evidence to show that this part was stopped up. They assert, as its very high is the 1827 order only evidences that the Quarter Sessions thought it needed to reserve public footpath up to the southernmost point marked K, where the road turns to the east, and not to the northernmost point K, adjacent to the text stating to Bickford and Milton, as appears to be suggested by the applicant and the report. Officers also disagree with this comment. Attached to Appendix N is a comparison of the 1827 order plan and the claimed route. Points marked C to K on the order plan mirrors points A to B on the plan of the claimed route. Officers contend that the Quarter Session does not support the whole of the route, only A to B. The applicant relies on the 1910 Finance Act material and the parish survey to support Part B to C of the claimed route. The Monkton's legal advisors concluded in saying their clients are concerned with issues of health and safety if members of the public are permitted to cross their active farmyard. Secondly, their clients would have to restrict their operations of the area affected, and this would involve making several redundancies. Thirdly, their clients would need to relocate some operations from the area affected to the other areas, and this would require the pursuit of planning consent to build on what would otherwise remain as greenfields. Whilst the landowners appreciate that these are not considerations the panel can consider, they nonetheless wish to make it clear their reasons for continuing to rigorously oppose the application. This correspondence from the Monkton's legal advisors was forwarded to the applicant, and he responded via email on the 19th and 23rd of November 2019, which can be found at Appendix P. The applicant also does not accept that the 1828 court decision in any way affected the reserved footway rights resolved by the 1827 court order for the reasons expressed in his communication of December 2018. He concluded with the application route is concerned to the north of and outside of the boundary of the 1827 and 1828 order plan. He provided evidence and rationale for that part of the claim route in his December 2018 communication. The final report was circulated on March the 4th of this year, to which is being heard here today. The Monkton's legal advisors responded to the report. A copy of this response has been appended to the report. They firstly raised the issue of dedication as per the previous objections. Officers will continue to rely on the doctrine of lost modern grant. As stated earlier, at some point the claimed route came into being. We cannot evidence its origins, however, being that it was amongst routes named in the 1827 order as a footpath, then it would have been previously created or dedicated. The doctrine was devised to overcome the difficulty of common law prescription that use or enjoyment from 1189 had to be shown. Where use or enjoyment as of right for 20 years could be shown, the mere fact that the use or enjoyment could not have been going on in 1189 was not allowed to stop the operation of the prescription. The courts were prepared to accept that the use or enjoyment has arisen as a result of the grant post 1189 that had been subsequently lost. They then moved on to the parish survey card, stating it is not clear what the objection that was made. The objection was made by the Ramblers Association to the omission of the route. No details were found of the objection. As stated, the parish survey cards vary in the details they contain. Looking in the margin of the map, objection 1046 gives no determination date. It appears there may have been some difficulty deciding on this route. At some point, the determination was made and it was added to the supplementary maps for the draft. Further comments of the Finance Act material were made. Officers continued to assert and rely on the explanation and analysis of this material and the quarter session material contained in the report. Lastly, the Monkton's legal advisors mentioned paragraph 54 of the report. They state that a direct quotation was inserted from the applicant, however quotation marks were not used, asserting that it is inappropriate to have unacknowledged quotation. Officers state that this is a grammatical error. However, it is clear that the paragraph was referring to comments from the applicant, and viewed alongside the applicant's letter can be seen it was quoted from the original source. To summarise, the documentary evidence shows that Part A to B of the route is supported by the 1827 and 1828 quarter session. There is no order extinguishing this part of the route, and so it exists to this day. The 1910 finance documentary evidence supports Part B to C of the alleged route, passing through 3 fields in the plot 610. Penkridge survey cards also support Part B to C. There was an objection received regarding the omission of the alleged route. Consequently, this route was then added to the parish survey. The fact that the route is not shown on any other maps after this time does not mean that it has ceased to have any public status, as the rule of law is that once a highway, always a highway. Neither that it fell into disuse, as there is no further record of its existence, is immaterial, nor can the existence of any obstructions have any bearing. And so, Chair, members, in light of the evidence set out before you, it is officers' opinion that the evidence shows that a public right-of-way with the status of a public footpath, which is not shown on the map and statement, is reasonably alleged to subsist.
Thank you for the report, the extensive report even. Very good. Obviously, as has been said by our officer, we can't take things like health and safety and such like on this. This is the legal requirement to look at this route under section 53. So I appreciate what you're saying there. Just for clarification for me, if the committee is minded to approve this, will the landowner be able to apply for a diversion?
Yes, yes.
Thank you. Paul?
Thank you, Chair. Sam, thank you for an excellent report. I feel, to go with your recommendation really, because you broke it down to A, B, then B to C, with different evidence from the three, the Magistrates Court Act, the Parish Survey, and the Highways Act. So I see where you're coming from. And making this decision, I'm not considering item 54 at all. You've given an explanation to that. It should have been inverted commas, but it wasn't, so I'm not taking that as part of my decision for making this decision at all. The Chair has just mentioned about the diversion. I was going to mention that as well. If we do put it through, the applicant's got the right to ask for diversion, and I hope that you would write to them when you actually do and tell them that we can bring it back before this, really. And as we say from our training, all the reasons that they've given in their letter of objections and Nocton's legal advisors don't give us grounds where we can turn this down if we decide to put it forward. So on those basis, I would propose that we go with officer's recommendation.
David?
Chairman, I think in my time on this committee, which I've sat through a lot of reports, I think this is one of the most comprehensive and long reports that we've had to consider, and I think we would congratulate the officers for the preparation of that report. I would only make the comment, which is nothing to do with the content of the report, but I think the report is so long. I've raised with Zach the fact that on the public internet the report is so large that most domestic computers would not download it, and so I think we ought to make an approach to IT about the possibility of compressing some of these extremely long reports so that they will actually download, and I would request that we consider that. I've no question at all about seconding the report, Chairman.
Slightly remiss of me, was there any input from the local member?
No.
Okay, thank you. Yes, I'd like to sort of reiterate what's been said. This has been a very extensive report, and it's also the applicants, the objectors have put a lot of time and effort into it, so well done everybody, and it's given us the chance to make a reasoned decision about this, and as such we've got a proposal to accept the officer's recommendations, a seconder, and I'll go along with it as well, so we take this item as going along with the recommendations of the officers. So thank you both very much. That is the final agenda item apart from exclusion of the public. And I need to just read out a paragraph. And that is that the public be excluded from the meeting for the following items of business which involve the likely disclosure of exempt information as defined in the paragraph of Part 1 of Schedule 12A, brackets as amended, of the Local Government Act 1972 indicated below. So could we wait while the webcast is finished?